Any mention?
My lord, I beg to mention item number 18, Your Lordship. Item number 18 for adjournment. Can it be fixed on 16, Your Lordship? There is another matter connecting matter with this one.
Okay. And pre-made by Mr. Learned Counsel for the Appellant. This is matter on 16.
Oblige.
May I please, Your Lordship? Your Lordship, I beg to mention item number 10, Your Lordship. Lordships, I beg to mention item number 10, Your Lordship. I am praying for 1 week's time to prepare this matter, Your Lordship.
Two weeks. Been heard.
It has not been heard. 2 weeks, Lord.
2 weeks. On pre-made by Appellant. 2 weeks.
Highly obliged.
May I please, Your Lordship, I beg to mention item number 5, Your Lordship. May this matter come up after 2 weeks, Your Lordship. The matter is still pending before the Coordinate Division Bench, Your Lordship.
2 weeks.
Oblige.
Lord, I beg to mention item number 13. 13. It did come after 2 weeks, man. 2 weeks, no.
30, no? 2 weeks.
13.
I beg to make the mention for item 9, Your Lordship. In this matter, I'm praying on behalf of Mrs. Thapa, Your Lordship. He's out of station, Your Lordship. Item 9.
3 weeks.
Fully obliged.
Me, please, Lordships. Lordship, I beg to mention item number 8. Also, I'm praying for 2 weeks' time.
2 weeks.
2 weeks.
Obliged.
Supplementary list, item number 1.
Please, Lordship. This is an appeal, Lordship, against the conviction where I was sentenced for
Mrs. Chandai, Lordship, is legal aid counsel.
Pass over.
Item number 3.
My lord, this is a contempt matter, my lord.
Are you really pressing this matter because you filed an execution order? Well, this is that matter where for my lord's enforcement of an arbitration interim award, my lords, this contempt application was filed. Now, your lordships have heard us at some length on various occasions on this issue, because, my lords, we are contending that the contempt application could not have been placed in the manner in which it has been placed before my lords. Now, the development is, my lords, that for enforcement of the interim award, they have filed an execution application before the learned district judge Shillong, and that is pending, my lords. That's an admitted position. I don't think my learned friend would also dispute that. In that event of the matter, my lords, I don't think anything survives in this matter.
That is not correct. My lord,
Mr. Paul,
Well,
you correct me if I'm wrong, but I'm made to understand that a contempt matter is between the court and the.
true, my lords.
It is for the court to look into the materials.
Lordship. I was only suggesting this because, my lords.
To ascertain whether there is contempt or not.
Lordships.
And it's for the parties to convince the court
Lordships.
otherwise.
Lordships, absolutely.
So, in that regard, the contempt application would survive until it is disposed of in accordance.
Well, it's, as your lordships were also part of that bench, well, it's division bench of this honorable court has already held in another matter that contempt application does not lie for enforcement of a decree for payment of money.
that is correct position of the law, my lord.
That may
my
be
lords,
argued by you.
Therefore, my lord, we have filed
so
the
once that be the position, my lords, I don't think this application lies. Otherwise, also, my lords, we had argued before your lordships.
So we'll hear the parties.
My lords.
We'll hear the parties. But Mr. Sankon, I think you have to refresh your.
Yes, my lord. My lord, this contempt, my lord, this has been filed for violation of the order, my lord, order dated 8/11/2023, as well as the corrigendum dated 10/11/2023, my lord. Now, my lord, I'll just give a brief background of this case, my lord. Now, my lord, between the contemptor
Yes.
and the petitioner, my lord, there was an agreement, my lord, and this agreement was for the purpose of development of the urban affairs parking lot cum shopping complex situated at Khandailat, Shillong. Now, the agreement was executed, and thereafter, my lord, the contemptor has approached the court for they have initiated the arbitration proceeding. If my lord will come to paragraph 2 of my petition, the contemptor has invoked the arbitration clause.
Just a moment.
Paragraph 2, my lord.
Paragraph 2.
Yes, my lord. Here, my lord, I have stated that the contemptor have invoked the arbitration clause vide notice dated 16/4/2021 under section 21 of the Act of 1996 in connection with an agreement dated 29/11/2010 entered into between the petitioner and the alleged contemptors. The said agreement was executed with respect to the development of the urban affairs parking lot cum shopping complex situated at Khandailat. It is submitted that in the said arbitration proceeding, the petitioner has filed its counterclaim of rupees 4 crores along with statement of defense to the statement of claim filed by the alleged contemptor. Now, thereafter, my lord, the petitioner has filed an application under section 17, that is at paragraph 3, my lord, I have mentioned. Application was filed under section 17 of the Arbitration and Conciliation Act, my lord, and sought urgent interim direction from the tribunal. And thereafter, my lord, the tribunal has passed the order, that is at page number 19.
Yes.
Just go to the relevant portion, my lord, that is at next page, that is page number 20. paragraph 4 and 5. That is important. It says, my lord, however, since it is an admitted position that the claimant is in possession of the subject premises, and as there is a huge claim of non-payment of such dues towards rent for a long period, we deem it appropriate to direct the claimant to deposit and pay the entire admitted and contractually fixed rent of the subject premises to the respondent number 1, effective from 7/6/2022, the date of issuance of notice under section 21 of the Act, to 31/10/2023, along with all government taxes dues within 6 weeks from today on or before 20/12/2023, for which receipt shall be granted by the respondent number 1. So far as period from 1/10/2016 to 6/6/2020 is concerned, and which is subject matter of the counterclaim, the claimant shall furnish a bank guarantee of an amount of 2 crore in favor of respondent number 1, which shall be made valid and operative till the disposal of this arbitration proceeding. We consider this amount of rupees 2 crore for which bank guarantee is to be furnished is reasonable and equitable, as it is only 50% of the claimed amount of the respondent number 1. In our opinion, this court would protect the interest and equity of both parties. So this direction was given, and thereafter, my lord, at page number 23, one corrigendum was issued. Page number 23, my lord.
Yes.
It says, my lord, it is pointed out by one of us, namely Justice B.K. Sharma, that there are small clerical typographical error in the order issued by this tribunal in procedural order dated so and so. Having gone through the same, it is established that there are in fact typographical clerical error which are required to be rectified by passing an effective order thereto. Consequently, corrections as deemed necessary and required in para 4 and 5 in the order dated so and so are done in the following manner. Consequently, in end of para 4, after completion of the last sentence ending with the word granted by respondent number 1, a new sentence shall be added to the extent in so far as the period from 1/11/2023 is concerned. Monthly rental masonry profit for the user of the subject premises shall be paid by the claimant to the respondent number 1 of the entire admitted and contractually fixed rent for every month, which shall be continued to be paid along with all state taxes and dues in the first week of every consecutive month till the passing of the award in the instant matter, for which a receipt shall be granted for the payment received by the respondent number 1. Similarly, in para 5, next page, my lord, para 5 of the order, the date mentioned as 6/6/2020 is typographical mistake, and the same should be read as 6/6/2022 instead of 2020.
Just a one.
That is
Page 24.
page number 25.
What is different? Correction. Then the signature.
And the Contempt of Courts Act. How many copies do you have?
Okay.
Yes. So this was the correction which was done, and therefore, my lord, in an application was filed, my lord, that is at page number
26.
Page number 26, my lord. An application was filed under section 27, clause 5 of the Arbitration and Conciliation Act. If my lord will see the section 27, clause 5, if my lord has the copy of Arbitration and Conciliation Act.
What am I supposed to do? Tell him to inform that I'm on legs. Yeah?
Yes.
Now, this section 27 clause 5 it says, my lord, persons failing to attend in accordance with such process or making any other default or refusing to give their evidence or guilty of any contempt to the arbitral tribunal during the conduct of arbitral proceeding shall be subject to the like disadvantages, penalties and punishment by order of the court on the representation of the arbitral tribunal as they would incur for the like offences in suits tried before the court. Now, because there was no compliance to the order passed by the arbitral tribunal, the application was preferred under section 27 clause 5, because in terms of the act, the arbitral tribunal has to refer the matter before the Honorable High Court for taking up contempt proceeding, because there was no power. That is the position, it was the position before, my lord. However, as they have not complied with the order, we have filed this application and subsequently an order was passed, that is at page number 9, my lord.
Page number 9.
Yes.
Okay.
On the basis of our application, my lord, this order dated 19/2/2024 was passed by the arbitral tribunal. The relevant paragraph is paragraph number 5, that is at page number 11.
Yes.
Now this paragraph it says, since this tribunal does not possess the power and jurisdiction to take action under Contempt of Court Act, yet we feel that this matter would require a strict actions and therefore the contempt proceeding to be taken up by the Honorable High Court of Meghalaya. We therefore refer the matter to the registry of the Honorable High Court of Meghalaya for placing the matter before the Honorable Chief Justice of the Honorable High Court of Meghalaya to pass necessary orders for doing the needful in the matter. The matter shall be placed before the registry with this order along with all other relevant documents by the counsel appearing for the respondent number 1. We may however make it clear that this order would not be in any manner construed as a fetter on the rights of the respondent number 1 to take all other course of actions that may be available to the respondent number 1 for such non-compliance in accordance with law. One of the contentions which has been raised by the learned senior counsel is that we have filed this contempt petition directly. We should have given before the registry instead of coming directly before this court. Now, yes, it is true that we have not given any letter before the registry directly. Rather, we have preferred to file this contempt application directly before the court. Now, my lord, there is a judgment of the Honorable Supreme Court.
The citation, please.
Yes, yes. There is a judgment. In this judgment, my lord, paragraph 8 and 9, my lord. I'll just read, my lord. Page 1 to 4.
Okay.
I'll just read, my lord. Paragraph 8. Coming to Sri Rana Mukherjee's submissions that subsection 2 of section 17 introduced by the 2015 Amendment Act now provides for the necessary remedy against infraction of interim orders by the tribunal. Sufficient to state that the Law Commission itself in its 246th report found the need to go one step further than what was provided in section 27(5). As construed by the Delhi High Court, the Commission in its report had this to say: power of tribunal to order interim measures. Under section 17, arbitral tribunal has the power to order interim measures of protection unless the parties have excluded such power by agreement. Section 17 is an important provision which is crucial to the working of the arbitration system, since it ensures that even for the purpose of interim measures, the parties can approach the arbitral tribunal rather than await orders from a court. The efficiency of section 17 is, however, seriously compromised given the lack of any suitable statutory mechanism for the enforcement of such interim orders of the arbitral tribunal. In Sundaram Finance Limited versus NEPC India Limited, the Supreme Court observed that...
What does section 17?
I'll read, my lord, that section 17. If my lord will just go ahead first with this order, we will read the section 17 as well. The Supreme Court observed that though section 17 gives the arbitral tribunal the power to pass order, now section 17, my lord, in short I will just say, it gives the power to pass interim measures. It says interim measures ordered by arbitral tribunal. That is section 17. It can pass interim measures. Now, section 17 of the Act, the court had held that under section 17 of the Act, no power is conferred on the arbitral tribunal to enforce its order, nor does it provide for judicial enforcement thereof. In the face of such categorical judicial opinion, the Delhi High Court attempted to find a suitable legislative basis for enforcing the order of the arbitral tribunal under section 17 in Sri so-and-so. The Delhi High Court held that any person failing to comply with the order of arbitral tribunal under section 17 would be deemed to be making any other default or guilty of any contempt to the arbitral tribunal during the conduct of the proceeding. Under sections 27(5) of the Act, the remedy of the aggrieved party would then be to apply the arbitral tribunal for making a representation to the court to mete out appropriate punishment. Once such representation is received by the court from the arbitral tribunal, the court would be competent to deal with such party in default as if it is a contempt of an order of court, either under the provision of the Contempt of Court Act or under the provisions of Order 39 Rule 2A of the Code of CPC, Code of Civil Procedure. The commissions believe that while it is important to provide teeth to the interim orders of the arbitral tribunal as well as to provide for their enforcement, the judgment of the Delhi High Court in Sri Kishan versus Anand is not a complete solution. The Commission has therefore recommended amendment to section 17 of the Act, which would give teeth to the order of the arbitral tribunal, and the same would be statutorily enforceable in the same manner as the order of a court. In this respect, the views of the Commissions are consistent with though do not go as far as the 2006 amendment to Article 17 of the Ancestral Model Law. Paragraph 9, pursuant to this 246 report, subsection 2 to section 17 was added by the 2015 Amendment Act so that cumbersome procedure of an arbitral tribunal having to apply every time to the High Court for contempt of its order would no longer be necessary. My Lord, may kindly see section 17 clause 2 that was added subsequently. By way of an amendment. Section 17 clause 2 says, my lord, subject to any order passed in appeal under section 37, any order issued by the arbitral tribunal under this section shall be deemed to be an order of the court for all purpose and shall be enforceable under the Code of Civil Procedure in the same manner as if it were an order of the court. Now, going ahead with the same paragraph, my lord, paragraph 9, it says, such order would now be deemed, after the amendment, such order would now be deemed to be order of the court for all purpose and would be enforced under Civil Procedure Code 1908 in the same manner as if they were order of the court. Therefore, because now after the amendment there is no requirement to file an application under section 27 clause 5 before the arbitral tribunal, and tribunal will send before the Honorable High Court to take up the contempt proceeding. Petitioners can directly come before the court after this amendment of section 17 clause 2, which was added subsequently. So because it has been deemed as a order of the court, and once there is a violation of the order of the court, anybody can come before the court and file the contempt proceeding. So therefore, the contention of the contemptor that this proceeding is not maintainable because we have approached this court directly without going before the registry, my lord, as per direction. However, the order of the tribunal also was very clear that we can approach the court and do all necessary whatever for non-compliance in accordance with law. So, my lord, my only humble prayer, my lord, for now, till today, my lord, they have not complied with the order. Therefore, it is a violation of the order of the court, and both the proceeding, my lord, under Contempt of Court Act and under CRPC for executions, those are two different proceedings. One, my lord, if the court finds that there is a violation of the order of the court will punish. In other, my lord, that is for executions where the money will be recovered. These are two different proceedings, they both can go simultaneously, my lord. So there is no bar, that is all, my lord. And therefore, my lord, my submission is that, my lord, the contempt proceeding should be initiated against the contemptor because, my lord, they have not obliged and not carried forward with the order of the tribunal, my lord, till today. That's.
Do you have any authority on the aspect of the matter as initially objected to by Mr. Paul, that once the execution proceeding has been initiated, then no issue of contempt has become infructuous?
No.
You try to
They
find
have not.
because
We'll try, my
you
lord.
you have made a proposition that the two proceedings can simultaneously proceed.
Yes, ma'am. Yes, well, we'll try to find out and in support we'll give it.
So, done.
Any day, my lord.
Should I begin? So,
Yes.
this is the first issue that before my learned friend Melons goes into the aspect of the merits of the matter, what had been argued before my lords at the first instance, my lords, would have to be taken into consideration. Now, what are the directions passed by the tribunal, my lords, would be relevant for my lordship's purposes, my lords. May I take your lordships to the directions passed by the tribunal at page 11, my lords, paragraph 5, what my learned friend read.
Yes.
Last line, my lords. We therefore refer the matter to the registry of the Honorable High Court of Meghalaya for placing the matter before the Chief Justice of the Honorable High Court of Meghalaya to pass necessary orders for doing the needful in the matter. Now, allegedly, my lords, this contempt application has been filed under section 12 of the Act by the petitioners pursuant to this order. Now, your lordships would have seen that the directions of the tribunal are very specific. It is a reference made by the tribunal before this honorable court, if at all. Admitted position is there is no reference by the tribunal before my lords till today. What is before my lords is an application under section 12 of the Contempt of Courts Act, filed by the petitioners. So the question therefore arises, my lords, is whether in the first place, in the face of this order, it was open to the petitioners to file any application under section 12 before my lords. That's the first question. Because two parallel proceedings cannot be there, my lords. That reference the tribunal can make even today. If the reference is made, then, my lords, what is the status of this? Whether there can be two parallel proceedings, the answer is in the negative. There cannot be two parallel proceedings in respect of the same proceeding, same matter. The reference, my lords, what they ought to have done, and I'm not here to advise them, but what would have been the proper procedure is it would have to be a reference under Rule 5 of the Meghalaya High Court rules, and I'll take your lordships to the rules. Now, my learned friend has read section 17 But before I read section 17, my lords, the judgment which my learned friend was reading, if your lordships kindly have a look at what was the opinion of the Delhi High Court. My learned friend read it. This is at paragraph 8 of the judgment, subparagraph 48. This is the observations of the Delhi High Court in that Sri Kishan Anand's case. My lords. If my lords kindly have a look at it. I think it is page 125. Para 48, my lords.
Yes, yes.
I'll quickly read the first part, my lords, and then I'll stop where the relevant portion is. In the face of such categorical judicial opinion, the Delhi High Court attempted to find a suitable legislative basis for enforcing the orders of the arbitral tribunal under section 17. The Delhi High Court held that any person failing to comply with the order of the tribunal under section 17 would be deemed to be making an order making any other default or guilty of contempt of the arbitral tribunal during the conduct of proceedings under section 27(5) of the Act. The remedy of the aggrieved party would then be to apply to the arbitral tribunal for making a representation to the court to mete out appropriate punishment. Once such representation is received by the court from the appellate tribunal, the court would be competent to deal with such party in default as if it is in contempt of an order of the court. So the two aspects of the MLS. One, that they must make a representation. Two, there must be a reference by the court to the tribunal to a court. That was one procedure. Then, my lords, the second limb of the argument which my learned friend has argued and is reproduced at para 9 is that there has been an insertion of section 17 subsection 2. Now, section 17 subsection 2, my lords, I'll take your lordships again. My lords, it reads, subject to any orders passed in an appeal under section 37, any order issued by the arbitral tribunal under this section shall be deemed to be an order of the court for the purposes and shall be enforceable under the Code of Civil Procedure in the same manner as if it were an order of a court. My lords have it.
Yes.
Now, my lords, to my humble understanding of this entire procedure would be twofold. A, my lords, I have two options. A, I can either file an application under section 27 before the arbitral tribunal, pointing out to the arbitral tribunal, yes, there has been some violation of your orders, kindly make a reference to the court. That option is option A. Option B, after the amendment, my lords, would then be to file a contempt application before this honorable court under Rule 5, and then my lords will then deal with it under Rule 5 of the Meghalaya High Court rules or the extant rules of the relevant High Court. Here, my lords, admittedly, they went and filed a section 27 application before the tribunal. The tribunal then says, my lords, we will make a reference. Till date, that reference has not been made. In the face of such facts, therefore, the question arises whether an application under section 12 is then maintainable before this honorable court. My humble submission is in the negative. Why, my lords? I'll take your lordships to Rule 5 of the Meghalaya High Court Contempt of Court Rules 2013. Before that, my lords, kindly have the Contempt of Courts Act. No. Subordinate courts. 10. My lords, may kindly have a look at section 10. Section 12, my lords, essentially deals with orders passed by my lords, the High Court's orders, my lords. Section 10 deals with the power of contempt in respect of orders passed by subordinate courts.
Yes.
If my lords kindly have section 10. Power of the High Court to punish contempt of subordinate courts. This, my lords, would have to be read in conjunction with subsection 2, where they say any order is passed would essentially be an order passed by a civil court. Every High Court shall have and exercise the same jurisdiction and power and authority in accordance with the same procedure and practice in respect of contempts of courts subordinate to it,
as it has and exercises in respect of contempt of itself. So, my lords, if I may now take your lordships to the Contempt of Courts, High Court of Meghalaya Rules 2013.
And this speaks of contempt before the High Court.
I'm sorry, my lords.
Section 10 speaks of contempt before the High Court.
No, my lords.
Subordinate courts. Yes.
Subordinate courts. These are two distinct powers, my lords. One would be contempt of anything, my lords, that happens before my lords. That would essentially be contemplated under section 14, if I'm not mistaken, my lords. Contempt on the face of the court. And, my lords,
12. Okay.
12 is the punishment, my lords. Section 10 deals with the power of punishment for subordinate courts. That read in conjunction with, my lords, section 17(2), which says order of a civil court, it has to come by way of reference. Now, the procedure, my lords, is laid down in Rule 5. If I may take your lordships to Rule 5 of the rules.
Just a moment.
I think it will be at page 185 of the Meghalaya High Court rules.
Yes. Rule 5.
My lords, at page 185, my lords may kindly see Rule 5. So, every reference relating to the contempt of a court subordinate to the High Court shall be scrutinized by the Registrar General, who shall place the same before the Chief Justice or any other judge nominated by him in this behalf, or obtaining orders after noting therein the nature of the contempt. So, that also, my lords, is a reference application, usually made by the court whose order is alleged to be violated. It is not open for me to come and file an application under section 12 before my lords. As your lordships pointed out, my lords, the contempt is between the court and the litigant. So, the court which feels, my lords, that there is a violation of that order, subordinate courts in this country, my lords, unfortunately do not have the power of contempt vested in themselves. That power is vested solely in my lords. So, therefore, the procedure is, my lords, when I feel aggrieved that yes, my order is not being followed, it is being violated, my lords, I make a reference to the High Court. And it is on that reference, my lords, section 5 comes into procedure. It is scrutinized by the Registrar General, placed before Honorable the Chief Justice, my lords, and then it is appropriately dealt with as a reference contempt, not as a civil contempt before my lords. Now, this, my lords, scenario arises because they chose to file a section 27 application before the tribunal. Had they not filed that, my lords, and come before my lords directly under section, then probably, my lords, an application under section 12 could have been maintainable. That's the first limb of my argument. I may also draw your lordship's kind attention to Rule 9, my lords. And Rule 9(3) is very specific. Rule 9(c) is very specific. If my lords kindly have a look at it.
Yes.
Civil contempts. In cases of civil contempt other than contempt referred to in subsection section 14, 14, my lords, is where the contempt is on the face of the court, my lords, essentially criminal contempt, may take action on its own motion or a petition represented by the party aggrieved, or in case of any civil contempt of a subordinate court on a reference made to it by that court. The admitted position is, my lords, there is no reference by that court before your lordships. In the face of that, my lords, therefore the question arises whether this application is maintainable. My humble submission is it is not maintainable. The second aspect of the matter, my lords, which then arises is, my lords, I may draw your lordship's kind attention to the, of course, if your lordships, my lords, decide this entire matter on this issue of maintainability, I need not even go into the issue of parties. Because who are the parties, my lords, may kindly see, only the managing director is added as a party and the company is added as a party. Your lordships are aware, my lords,
Contempt, if at all there is contempt, my lords, the board of directors would have to represent the company. That has not been done.
The managing director is usually the
Managing director is, my lords, only one person. He is not the board of directors. Company cannot be represented by the managing director, my lords. If it is to be punished, my lords, your lordships are aware of the standard chartered judgment. I can place it for my lords. That it is only the board of directors, my lords, which will then be responsible, and the entire board would then have to be before my lords. That has not been done. That's these, my lords, that's on the technical side. And more importantly, the query that fell for my lords, I've already annexed that order. My lords were part of that bench. This is the judgment on order, my lords, passed in contempt case number 1 of 2023. It's passed by a division bench of my lords, Honorable, the then Chief Justice, Honorable Justice Banerjee and my lords, sitting in division bench. It's, my lords, we filed it by way of an affidavit. This is the affidavit dated 1/7/2024. This is a preliminary affidavit that was filed by us. Annexure 1 of that affidavit, my lords. Last page, if my lords can have a look.
Yes, ma'am.
Just be there. Now, my lords, before we go into this judgment,
Yes.
my lords, as has been argued by my learned friend, and I'm grateful to my learned friend for having read, my lords, what is the grievance of the contempt petitioner before my lords.
Yes.
They say that there was a direction to pay money. You have not paid the money. Therefore, you are in violation of that order.
Yes.
It is, my lords, indirectly for recovery of money. And my learned friend has been very candid. They have not paid for it. They have not paid it till today. I draw your lordship's attention to paragraph 6 of this judgment.
Yes.
My lords, you will kindly see. Ordinarily, the contempt jurisdiction cannot be invoked to enforce payment, particularly against a private writ petitioner. The petitioner will be entitled to enforce its claim against the respondent in accordance with law. Nothing in this order should prejudice the petitioner in such regard. However, contempt case number 1 of 2023 is completely flawed and dismissed. So, contempt jurisdiction, my lords, in my humble submission, cannot be used to coerce somebody to pay money.
So according to you, the option would be for an
Execution, my lords, which they have now done. And in execution proceedings, my lords, your lordships have seen, and 17.2, your lordships have also seen 17.2. Now, the intent of the legislature is that it is an order of a civil court. Execution court is duly empowered, my lords, under law to ensure the payment of money. The answer is not in contempt, and especially this contempt application, my lords, is absolutely misplaced because they would not be at liberty to file section 12.
But that, you see, that limb of submission or argument would come only when the contempt per se is taken up.
Well, I am challenging the maintainability at this stage.
Challenging the
maintainability at this stage.
We'll just have to see whether it's maintainable or not.
I am saying, my lords, it's not maintainable in the first place.
Exactly.
Because, my lords, that option of filing section 12 is not available with the petitioners. Once you have exercised 27, you have gone before the tribunal, then the law says, my lords, the tribunal will make a reference. Read with Rule 9C and Rule 5 of the Meghalaya High Court rules. Admittedly, that has not been done. If that is not done, my lords, it is not open for you to file section 12. Then, my lords, the proper option would have been to file under section 10. That also by whom? By under Rule 9, my lords, by the court concerned.
So, my lords, that judgment which my learned friend has placed before my lords is actually of no assistance to him. It rather helps me, because I've pointed out, my lords, that Delhi High Court says that under 27, reference two things, my lords: representation to the court and representation to the tribunal, and, my lords, reference by the tribunal to the court.
But that judgment is a clarification of the section 17.
Which I then, my lords, therefore the second level of the submission, if you had then exercised 17.2 at that stage, then it would be a different case altogether. Probably then this argument would not be available to me.
So, Mr.
My lord, one small
Well, they're not disputing.
point I want to raise, my lord. My learned friend, senior, he has pointed out as regard to the judgment that I have relied. My lord, may kindly see paragraph 9 of the same judgment. My learned senior has stated that there has to be reference.
I've read 9 as well.
Now, paragraph 9, my lord, categorically it states, pursuant to this 246th report, subsection 2 to section 17 was added by the 2015 Amendment Act, so that the cumbersome procedure of an arbitral tribunal having to apply every time to the High Court for contempt of its order would no longer be necessary. Such order would now be deemed to be order of the court for all purpose and would be enforced under the Civil Procedure Code 1908 in the same manner as if they were order of the court.
Absolutely,
So
my lords.
this point, my lord, which my
I'm
learned
not
senior
disputing
has
what my
said,
learned friend is saying.
that there has to be a reference by the court. That is not true. After the amendment, my lord, parties, aggrieved party can come directly before the court. Now, my lord, may kindly see the power at section 10 of the Contempt of Court Act 1971. It clearly says, my lord, power of High Court to punish contempt of subordinate courts. So, tribunal being the subordinate court, this court has the power, and as well as, my lord, the High Court of Meghalaya Rules 2013, section 9, my lord, it says, in the case of a civil contempt other than contempt referred to in subsection 14, the High Court may take action on its own motion on a petition presented by the aggrieved party. Now, I being an aggrieved party, I can definitely come before the court, my lord, before this court, and file an applications. And moreover, the order of the tribunal, my lord, at paragraph, the last paragraph, section 12, page number 12, my lord, it categorically made a statement in the order. It says, we may, however, make it clear that this order would not be in any manner construed as a fetter on the rights of the respondent number 1 to take all other course of action that may be available to the respondent number 1 for such non-compliance in accordance with the law. Now, direction of the tribunal was to make payment of the rent due. Now, my contention is they have not complied with the order of the tribunal. Now, question here is, my lord, whether they have complied with the order of the tribunal. That is the questions. If my lord finds that the order of the tribunal have not yet been complied, then they are in contempt of court, my lord. That is, therefore, my lord, the contempt proceeding has to be initiated, my lord.
Have you heard the parties?
Well, we had already filed our written notes of argument.
You have filed?
We've already filed.
Have you filed yours?
Already on record.
We'll file it, my lord.
1 week?
You filed also.
We have, my lord.
Both parties have filed, my lords.
Have you filed or not?
Probably, my lord. Just check.
It was filed in
Probably we have filed, my lord, because the argument was already concluded earlier.
February 2025, my lords.
Okay. But you, the authorities that you want to...
My lord, we'll submit.
So we'll reserve the judgment, and in the meantime you submit to the authorities.
Challenge.
But Mr. Answer Leonard G. for the petitioner, the state petitioner. Also Mr. K. Paul, assisted by for the respondent contender. Hearing concluded. Judgment reserved.
Well, it would only be on the issue of maintainability. If my lords
Yes.
then hold it, it's maintainable, then my lords, of course, the proceeding.
Exactly. Only on the issue of maintainability.
Obliged.
Item number 4.
Made, please, Your Lordship. Lordship, this is a legal aid matter. There's a delay, Lordship, in preferring the appeal. So we have
Who's appearing?
filed an application for condonation of delay, Lordship. There is a delay of 780 days, Lordship, in preferring the appeal, Lordship.
Mr. Gurung, you're in this case?
No, my lord, but since part of the government, my lord, I'm there.
आगे तो गयो तो जो order वहाँ पास में है वही order so delay control
Delay करना चाहिए.
check की details है
Any mention?
Lordship, I beg to mention item number 5 and 6.
I'm going to respond
to 5 and 6.
What is this matter about? 2022
Assam
matter?
Rifles matter.
Assam Rifles?
Service matter.
You are in this case, miss?
M. Tiwari.
You are in this case? Yes.
Yes, Lord. Your Honor.
On prayer made by Miss M. Tiwari and counsel for the petitioner seeking accommodation. That is adjourned. Let's just say after 2 weeks. 2 weeks.
Obliged, Lordship.
Obliged.
Please, Your Lordship, I beg to make a mention of item number 9. It's connected matter with item number 10, Your Lordship. Lordship, I pray that this matter may come up on the 16th of this month. I pray that this matter may come up on the 16th of this month.
On prayer made by this letter counsel for the petitioner. This is matter to 2 weeks.
2 weeks. Apply.
Lordship, similar prayer for item number 12.
Weeks.
Much obliged, Lordship.
May it please, Your Honor. Your Lordship, I beg to mention item number 2.
Number 2?
Conducting. Yes, item number 2.
Order portion, no mention. Let it be called up. You can make your submission.
May I please, Your Lordship, I beg to mention item number 7, Lordship. May this matter come up after 2 weeks, Your Lordship? The conducting counsel is out of station.
I think this matter has been heard.
It has already been heard, Your Lordship. So
We're
far,
supposed to
so
give
far
a
the
reply.
state is concerned, Your Lordship. We have made the submission, Your Lordship. We said
That we have no role, Your Lordship.
Who's appearing for the
For the
Private-
other
private
respondent, Your
respondent?
Lordship, is Mr. Khriam.
Oh, Mr. Kriya, yes, you are there. So what is required now?
I think
supposed to give a
the
reply,
appellant
Your
has to reply to the
Reply.
submission made by the other respondent, Your Lordship.
On prayer made by Ms. Learned Counsel for the appellant. Matter is adjourned. This is same after 2 weeks.
Apply, Your Lordship.
Your Lordship, I beg to mention item number 11.
I have no objection, Lordship, but I would pray for an early date.
It can come up after a week, Your Lordship.
On prayer made by Ms. Leonard D. Appearing for the petitioner, state petitioner. Matter is adjourned. This is same after 1 week.
Obliged, Your Lordship.
Daily list item number 1.
For respondent 4. My lord, I am entering appearance for respondent number 4.
What about what? Who's respondent number 1?
Pranay Subba.
Lordship, I have filed my affidavit of service, Lordship, upon respondent number 1, Lordship.
Lordship, I am appearing on behalf of the respondent number 2 and 3.
Mr. Bora, learned counsel, has submitted that on receipt of notice, he is instructed to appear on behalf of the respondent number 4. Mr. Learned counsel is present on behalf of the respondent number 2 and 3 respectively. However, none has appeared on behalf of the respondent number 1. Though the learned counsel for the defendant has submitted that the affidavit of service has been filed in this regard, in view of the fact that the said respondent is not in attendance today, another opportunity is given to her to appear on the next date fixed. This is a matter of 2 weeks.
Item number 2.
May I please, Your Lordship?
Just a moment. Let us see first. What is this about? Paper book, so matter will be listed for hearing.
Yes, Your Lordship. And I may be allowed to receive paper book, Your Lordship.
Huh?
Paper book, I haven't received. I may be allowed to receive paper book, Your Lordship.
Is this a legal aid matter?
Yes.
As submitted by the learned counsel.
Item number 3.
As per the last order, the state was directed, my lord, to file a affidavit with regard to the operation of the review order passed by the Honorable Supreme Court dated 9th of December 2025, wherein the Supreme Court had categorically directed that instead of the state, now everything with regard to the degrees and the continuation of the studies of the students who are already admitted would be considered and dealt with only by the UGC and not by anyone else. But de-host to that, my lord, what has happened is UGC has been writing letters to the administrator, that is one of the respondents here, to allow the students to, my lord, give the examination, which he is not even responding and not even allowing us to, my lord, do the job. On the contrary, what has happened is, my lord, he is directing us to make payments on whimsical grounds to the teachers to the extent of 47 lakh for a period of only 6 months. The teachers would have been suspended, and yet he is directing 48 lakh compensation to such kind of teachers, which is not even the pay as per the UGC, even to the dean of a reputed university also, my lord.
Where is that?
I am going to bring it on record since they are, my lord, it happened during the all vacation, my lord, that so I can bring it on record. But the fact of the matter is they have not even filed the affidavit, my lord, as of today. If they can be directed, or my lord, the matter may be kept on a very immediate date so that we can.
But in the main case, we have already filed affidavit, my lord.
You have filed?
Yes, my lord.
The main reply has been filed, where the only ground they have taken is that the sponsor, that is us, is having no locus standi also to file this kind of
That will examine, my lord. These are the offshoots while the matter is pending. Now these offshoots will keep coming, my lord. So what I pray, if the main matter is heard and disposed of, my lord, that will naturally take care of all whatever.
What is your prayer in the main?
Kindly have my prayer. Kindly, there are 3 prayers. My writ has to be allowed, my lord, to some extent, and some issues are still there. Kindly have my page 108, my lord. The prayers start from 107, internal page. Page 107, my lord. And the relevant starts at issue a next page, my lord, 108. Issue a writ of mandamus or any other appropriate writ, or setting aside the public's notice dated 26th of March 2025, issued by the administrator CMJ University, dated by which the state government started the process of winding up the CMJ University by inviting claims and objections from the public without issuing notice to the petitioner under section 848(3) of the CMJ Act. This issue survives.
Okay, so basically you are aggrieved by the winding up process.
The manner in which they have.
Exactly.
Yes.
The process.
Yes.
So
And kindly have the prayer
one.
C.
That's number one. Number two.
Yes. Number two, I am not very much agreed, because this is anyway been allowed by the Supreme Court. The next prayer B is virtually, my lord, allowed by the Supreme Court.
Okay.
It is the UGC now who has to take care of it.
Fine.
The third prayer, which is at page 110, my lord.
Yes.
It starts from 7th line from the bottom, my lord. Issue a writ of mandamus or any other appropriate writ, or directing the state government to make such arrangement for the administration of the university in terms of section 48(3) and 4 of the CMJ 2009, from the date of dissolution of the university until the last batch of students are admitted, and pursuing from academic year 2015-16 to 2024-25 in regular courses of student studies of the university to complete their courses of studies in such manner as may be prescribed by the UGC regulation, by considering the fate of the student who had pursued or pursuing the courses from so and so date for the future. Now under this very, my lord, prayer, I am seeking a prayer, my lord, that the administrator has to act not like an aristocrat, but as a my lord, as per the
as a bureaucrat.
Yes, including us also. But he is acting like an aristocrat, passing orders without even calling upon us. When we say the teacher was suspended and he has worked only for 15 days, he is asking us to pay 48 lakh to him as a compensation. And not just one, my lord, 51 lakh, 65 lakh, my lord, 47 orders have been passed like this to various, my lord, persons without even asking us whether they were our employees or not. So he is, my lord, independently.
My lord, there is nothing on record, my lord.
I will bring it on record, my lord, but this prayer, the only thing I am pointing out, this prayer survives. Because he can't act like that, because he has to act.
So under this prayer, these are the, as Dr. Muzika said, these are the offshoots.
Yes.
The latest development.
Yes, my lord. And then the last prayer, issue or any other appropriate writ or directing the state government to prescribe the manner in which winding up this, my lord, is related to the first prayer. So basically only two prayers as of stand of today. That is prayer 1.
Under the relevant statutes, or
48(3), my lord.
Under the relevant provision of the statutes, this process would have been there.
No, this process has not been followed.
May I submit, my lord? The whole difficulty, my lord, after filing the present writ petition, my lord, these were the prayers set up in 2025, my lord. After that, Supreme Court has disposed of the review, my lord, with certain directions. Now we have to read the prayers in this writ petition along with the order passed by the Supreme Court and review, my lord. Now what I believe, my lord, some other review has also been filed with them.
No, the students, only the student, my lord. What has happened is there are more than 6,000
students. The outcome of that review also, my lord, because simultaneously seeking relief of a similar nature, my lord, from the Supreme Court and from this honorable court also, my lord. But that will lead us nowhere, my lord.
That
if
will
the
be
prayer, my lord, if I have got a, my lord,
aspect of the matter
kindly consider only one aspect, my lord.
That aspect of the
I
matter will be
totally agree that they were overlapping. But those overlapping has also, my lord, been curtailed now by the order dated 9th of December 2025.
Only to prayer B, my lord,
Just
as
one
my
second,
friend is
sir.
submitted. Only to prayer B, maybe to some extent, a certain clarity has been given, my lord.
If my friend would allow me, my lord, it is not
1, 3 and 4.
As far as the role of the UGC is concerned.
My lord.
No, my lord, the UGC's role has been now, my lord, defined. State has been ousted, which state is not, my lord, wanting to forego. That's one issue.
There's nothing
just
on
one
record,
second, sir.
Lord,
I will place it on record, but that doesn't mean that I can be just force shut just like that. I'm only seeking a short date.
Mr. Singh,
kindly have 48, my lord.
So all the how many respondents are there?
The 4 respondents, my lord. Everyone has filed their reply.
They filed.
Yes.
You file your rejoinder.
My what has happened is thereafter I place it on record. I place it on record. The order by the Supreme Court, to which they said we will file an affidavit. That is, my lord, kindly have the order dated 11th of December.
Have you done that?
Just I will read. It is prayed that sometime may be allowed for an affidavit to be filed in this.
Today, new submission. Let him bring on record whatever. If we have done anything wrong, let him bring on record. We'll respond to that. We'll composite in a composite affidavit.
But supposing I don't, my lord. Supposing I don't, would they not comply with this order of this honorable court?
If you are not
supposing I don't, he can't ask my lord. Then also my learner senior friend.
Let him make
all I'm saying is have it on a short date.
Either he is filing or he is not filing. If he is not filing, we will file a reply, my lord.
Whatever has been stated at the bar pertains to certain, like you said, recent developments, which you need to respond to.
The recent developments we don't have a copy, my lord. He has to place on record.
Exactly.
Then we'll reply to that.
So Mr. Singh will file the same in the form of an affidavit, and you can respond to it.
My lord.
But as far as the earlier order is concerned, it is incumbent upon you to file your reply. If you have not been able to do so, say so.
As far as the last
order, saying is have a short date. That is my nut and.
As far as last order, my lord, kindly grant us 2 weeks time, my lord.
2 weeks time.
But if it's filing
have it of a week time, my lord, because what has happened is, my understand why I am seeking a short date. It is not like, my lord.
You also have to file your.
I may just bring it on record. That's all. I can do it tomorrow also. But the fact of the matter is, my lord, what is happening is students, my lord, who have the UGC is writing to the administrator.
Now, your students have gone to Supreme Court also. That's what he's saying.
Have it a short date, my lord, next week.
You suggested it.
Today's 4th.
Have it on 11th.
11th, 17th or 18th, my lord. 16, 17, 18. Any of those days.
16.
16.
16th is all right. Grateful. I'm so grateful, man.
Heard Mr. E.P. Singh, counsel for the petitioner, who has submitted that in course of these proceedings, certain new developments have arose which are relevant to the facts and circumstances of this case. It is prayed that such new developments, it is prayed that an affidavit in this regard may be allowed to be filed by the petitioner, bringing on to court